On this vote, the yeas are 427, the nays are 1. 2/3 being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table. Pursuant to Clause 8, Rule 20, the unfinished business is the vote on ordering the previous question on House Resolution 879, on which the yeas and nays are ordered. The clerk will report the title of the resolution.
House Calendar Number 47, House Resolution 879. Resolution providing for consideration of the joint resolution, Senate Joint Resolution 80, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Land Management relating to National Petroleum Reserve in Alaska Integrated Activity Plan Record of Decision, providing for consideration of the joint resolution, House Joint Resolution 130, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Land Management relating to Buffalo Field Office Record of Decision and approved Resource Management Plan Amendment, providing for consideration of the joint resolution, House Joint Resolution 131, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Land Management relating to Coastal Plain Oil and Gas Leasing Program Record of Decision, providing for consideration of the concurrent resolution, House Concurrent Resolution 58, denouncing the horrors of socialism, providing for consideration of the bill, H.R. 1949, to repeal restrictions on the export of import of natural gas, providing for consideration of the bill, H.R. 3109, to require the Secretary of Energy to direct the National Petroleum Council to issue a report with respect to the petrochemical refineries in the United States and for other purposes, providing for consideration of the bill, H.R. 5107, to repeal the Comprehensive Policing and Justice Reform Amendment Act of 2022, enacted by the District of Columbia Council, providing for consideration of the bill, H.R. 5214, to require mandatory pretrial and post-conviction detention for crimes of violence and dangerous crimes and require mandatory cash bail for certain offenses that pose a threat to the public safety or order in the District of Columbia, and for other purposes and for other purposes.
The question is on ordering the previous question. Members will record their vote by electronic device. This is a 5-minute vote. On this vote, the yeas are 217, the nays are 211. The previous question is ordered. The question is on the adoption of the resolution. Those in favor say aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it.
Speaker,
For what purpose does the gentleman from Massachusetts rise?
I ask for a recorded vote.
A recorded vote is requested. Those favoring a recorded vote will rise. A sufficient number having risen, a recorded vote is ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed. The House will be in order. The House will come to order. The House will come to order. For what purpose does the gentleman seek recognition?
To speak out of order for 1 minute, Mr. Speaker.
Without objection, the gentleman is recognized.
Thank you, Mr. Speaker. Today I rise to recognize a man whose dedication, steadiness, and wisdom have shaped not only my work in this chamber, but the work of this institution itself. I'm talking about my Chief of Staff, Brett Horton. There are few people who know Capitol Hill more intimately than Brett. For 15 years...
Gentlemen will suspend. The House will be in order. Gentleman's
For
recognized.
15 years, he's been by my side. He began as my counsel in 2010 and worked his way through some of the most demanding, consequential roles in the House. Policy Director at the Republican Study Committee, Floor Director in the Majority Whip's office, and for the last decade, my Chief of Staff in both the Whip's office and the Leader's office. To me and to countless members of Congress and staff, Brett Horton has been far more than a colleague. He's been a trusted advisor, steady in his approach, wise in his counsel, and deliberate in his words and actions. When the stakes were the highest, Brett's voice was the one you wanted in the room. His fingerprints are on every major Republican policy victory we've achieved in the past decade. But perhaps more importantly, he's been by my side through tough personal and professional challenges that extend far beyond legislating. In the aftermath of the congressional baseball shooting, an event that shook my family, my staff, and this entire conference in Congress, Brett's leadership and friendship were unwavering. He helped carry us through one of the most difficult and unprecedented challenges we ever faced. Mr. Speaker, public service at this level demands trust, character, and unwavering duty for the institution that is this United States Congress. Brett Horton embodies all of these qualities. I'm profoundly grateful for his years of service to me personally, to this House, and to our country. As Brett begins his next chapter, I have no doubt he'll continue to serve with the same excellence that has defined his entire career. The United States House of Representatives is the stronger institution because of Brett Horton's distinguished service here. I wish Brett all the best in his future endeavors, and I tell you, thank you, Brett, for your personal friendship and for your service to this great United States of America and this great Congress. Thank you, Brett Horton.
Gentleman yields back. Pursuant to Clause 8 of Rule 20, the unfinished business is the vote on the adoption of House Resolution 879, on which a recorded vote is ordered. The clerk will report the title of the resolution.
Calendar number 47, House Resolution 879. Resolution providing for consideration of the joint resolution, Senate Joint Resolution 80, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Land Management relating to National Petroleum Reserve in Alaska Integrated Activity Plan Record of Decision, providing for consideration of the joint resolution, House Joint Resolution 130, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Land Management relating to Buffalo Field Office Record of Decision and approved Resource Management Plan Amendment, providing for consideration of the joint resolution, House Joint Resolution 131, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Land Management relating to Coastal Plain Oil and Gas Leasing Program Record of Decision, providing for consideration of the concurrent resolution, House Concurrent Resolution 58, denouncing the horrors of socialism, providing for consideration of the bill, H.R. 1949, to repeal restrictions on the export and import of natural gas, providing for consideration of the bill, H.R. 3109, to require the Secretary of Energy to direct the National Petroleum Council to issue a report with respect to the petrochemical refineries in the United States and for other purposes, providing for consideration of the bill, H.R. 5107, to repeal the Comprehensive Policing and Justice Reform Amendment Act of 2022, enacted by the District of Columbia Council, providing for consideration of the bill, H.R. 5214, to require mandatory pre-trial and post-conviction detention for crimes of violence and dangerous crimes and require mandatory cash bail for certain offenses that pose a threat to the public safety or order in the District of Columbia and for other purposes and for other purposes.
The question is on the adoption of the resolution. Members will record their votes by electronic device. This is a 5-minute vote.
On this vote, the yeas are 217 and the nays are 210. The resolution is adopted without objection. The motion to reconsider is laid on the table. Pursuant to Clause 8 of Rule 20, the unfinished business is the vote on adoption of House Resolution 878, on which the yeas and nays are ordered. The clerk will report the title of the resolution.
House Resolution 878, resolution disapproving the behavior of Representative Jesus G. Chuy Garcia of Illinois.
The question is on adoption of the resolution. Members will record their votes by electronic device. This is a 5-minute vote. On this vote, the yeas are 236, the nays are 183, with 4 answering present. The resolution is adopted. Without objection, the motion to reconsider is laid upon the table. The House will come to order. The House will come to order. For what purpose does the gentleman from South Carolina seek recognition?
Mr. Speaker, pursuant to Clause 2A1 of Rule 9, I rise to give notice of my intent to raise a question of the privilege of the House.
The gentleman is recognized. Just a moment. Members of the House will come to order. Chair would ask members to please take conversations off the floor. The gentleman is recognized.
Mr. Speaker, my House Resolution 888, censoring and condemning Delegate Stacey Plaskett and removing her from the House Permanent Select Committee on Intelligence for conduct that reflects the discredibility on the House of Representatives for colluding with convicted felon and offender Jeffrey Epstein during a congressional hearing. Whereas Stacey Plaskett, the delegate representing the United States Virgin Islands in the House of Representatives, inappropriately coordinated in real time with convicted sex offender Jeffrey Epstein in a congressional hearing in February of 2019. Whereas Delegate Plaskett was actively coached by Epstein during the hearing, receiving instructions on specific lines of questioning, and was congratulated after the message by Mr. Epstein, good work. Whereas Jeffrey Epstein, the Speaker of the House is not in order.
The gentleman has the floor. The chair would again ask the body to please observe the quorum and keep conversations to a minimum. The gentleman has the floor.
Whereas Jeffrey Epstein was a known convicted felony sex offender, having pled guilty and been convicted for procuring a child for prostitution and solicitation, a proselyte in a plea deal in 2008, and served a 13-month prison sentence. Whereas in the course of that investigation, the FBI compiled reports on dozens of confirmed minors who credibly alleged sexual abuse by Mr. Epstein. Whereas Epstein was under further federal investigation beginning in November of 2018, 2 months before Delegate Plaskett's recently revealed text exchange during a congressional hearing, following investigative reporting by the Miami Herald detailing Epstein's controversial 2008 plea deal and highlighting accounts of his victims. Whereas Epstein was arrested in July of 2019 and charged with 1 count of sex trafficking of minors and 1 count of conspiracy to commit sex trafficking of minors, he was later found dead in the New York Metropolitan Correctional Center. Whereas according to documents released from Epstein's estate during a House Committee on Oversight and Reform hearing featuring testimony from Michael Cohen, the disgraced former attorney for President Donald J. Trump, Delegate Plaskett coordinated her line of questioning with Jeffrey Epstein in real time over text messages while the hearing was underway. Whereas Delegate Plaskett, who previously served as an Assistant Attorney General in the United States Department of Justice Civil Division, is known to have had extensive political, personal, and professional connections with Epstein after his conviction as a sex offender up to the time of his arrest and then his death in 2019. Whereas Delegate Plaskett's relationship with Epstein stands in stark contrast to the public image that she has curated for herself as a defender of justice and accountability, and while secretly collaborating with an individual whose crimes against vulnerable women and children shocked the entire nation. Whereas Delegate Plaskett's willingness to receive instructions on official congressional proceedings from Epstein, a convicted felony sex offender with deep concerning international associations, is especially alarming and inappropriate given her own past service in the United States Department of Justice and her current role on the House Permanent Select Committee on Intelligence, and raises serious questions about Delegate Plaskett's judgment, her integrity, and her fitness to serve. Whereas such associations erode public trust in Congress, particularly when they involve using input from a sex offender to advance partisan attacks during official proceedings. Now, therefore, be it resolved, Section 1, Censure of Delegate Stacey Plaskett. Resolved that the House of Representatives censors and condemns Delegate Stacey Plaskett for inappropriate coordination with convicted sex offender Jeffrey Epstein during a congressional hearing which reflects discreditably on the House of Representatives, and directs the Committee on Ethics to conduct a full investigation into the extent of Plaskett's ties to Epstein and any further improprieties. Section 2, removed from House Permanent Select Committee on Intelligence. The following named member be and is hereby removed from the following committee on the House of Representatives. Permanent Select Committee on Intelligence, Ms. Plaskett.
I recognize the gentleman from South Carolina to offer the resolution just noticed. Does the gentleman from South Carolina offer the resolution?
I do.
The clerk will report the resolution.
House Resolution 888. Whereas Stacey Plaskett, the delegate representing the United States Virgin Islands in the House of Representatives, inappropriately coordinated with convicted sex offender Jeffrey Epstein in a congressional hearing in February 2019. Whereas Delegate Plaskett was actively coached by Epstein during the hearing, received instructions on specific lines of questioning, and was congratulated afterwards with the message, "Good work." Whereas Jeffrey Epstein was a known convicted felony sex offender, having pled guilty and been convicted for procuring a child for prostitution and for soliciting a prostitute in a plea deal in 2008 and served a 13-month sentence. Whereas in the course of that investigation, the FBI compiled reports on dozens of confirmed minors who credibly alleged sexual abuse by Epstein. Whereas Epstein was under further federal investigation beginning November 2018, 2 months before Delegate Plaskett's recently revealed text exchange during a congressional hearing, following investigative reporting by the Miami Herald detailing Epstein's controversial 2008 plea deal and highlighting accounts of his victims. Whereas Epstein was arrested in July 2019 and charged with 1 count of sex trafficking of minors and 1 count of conspiracy to commit sex trafficking of minors, and he was later found dead in the New York Metropolitan Correctional Center. Whereas according to documents released from Epstein's estate, during a House Committee on Oversight and Reform hearing featuring testimony from Michael Cohen, disgraced former attorney to President Donald J. Trump, Delegate Plaskett coordinated her line of questioning with Jeffrey Epstein in real time over text message while the hearing was underway. Whereas Delegate Plaskett, who previously served as an Assistant Attorney General in the U.S. Department of Justice Civil Division, is known to have had extensive political, personal, and professional connections with Epstein after his conviction as a sex offender up to the time of his arrest and then death in 2019. Whereas Delegate Plaskett's relationship with Epstein stands in stark contrast to the public image she has curated for herself as a defender of justice and accountability, while secretly collaborating with an individual whose crimes against vulnerable women and children shocked the nation. Whereas Delegate Plaskett's willingness to receive instructions on official congressional proceedings from Epstein, a convicted felony sex offender with deeply concerning international associations, is especially alarming and inappropriate given her own past service in the U.S. Department of Justice and her current role on the House Permanent Select Committee on Intelligence, and raises serious questions about Delegate Plaskett's judgment, integrity, and fitness to serve. And whereas such associations erode public trust in Congress, particularly when this involves using input from a sex offender to advance partisan attacks during official proceedings, now therefore be it resolved. Section 1, Censure of Delegate Stacey Plaskett. The House of Representatives, 1, censures and condemns Delegate Stacey Plaskett for inappropriate coordination with convicted sex offender Jeffrey Epstein during a congressional hearing, which reflects discreditably on the House of Representatives, and 2, directs the Committee on Ethics to conduct a full investigation into the extent of Plaskett's ties to Epstein and any potential further improprieties. Section 2, removal from House Permanent Select Committee on Intelligence. The following named member be and is hereby removed from the following committee of the House of Representatives. Permanent Select Committee on Intelligence, Ms. Plaskett.
The resolution qualifies. For what purpose does the gentlelady from Massachusetts rise?
Mr. Speaker, I have a motion at the desk.
The clerk will report the motion.
Ms. Clark of Massachusetts moves to refer the resolution to the Committee on Ethics.
The gentlelady from Massachusetts is recognized for 1 hour.
Mr. Speaker, today we have finally taken a vote that recognizes the need for the survivors and victims of Jeffrey Epstein to have justice and transparency. And not minutes later, the gentleman from South Carolina is filing yet another partisan resolution. I ask all of my colleagues to support this motion to refer this to the Ethics Committee, and I yield back my time.
Without objection, the previous question is ordered. The question is on the motion to refer. All those in favor say aye. Aye. All those opposed say no. No. In the opinion of the chair, the noes have it.
Mr. Speaker.
And the motion is not up. What
Mr.
purpose?
Speaker, I request to call the yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. 5 minutes will be allowed for this vote. On this vote, the ayes are 213 and the noes are 214. The motion is not adopted. Without objection, the motion to reconsider is laid on the table. Pursuant to Clause 2 of Rule 9, the gentleman from South Carolina, Mr. Norman, and the gentleman from Maryland, Mr. Raskin, each will control 30 minutes. The chair recognizes the gentleman from South Carolina.
Thank you, Mr. Speaker.
And just a moment. The chair would ask the House to come to order again, ask members to take conversations off the floor so that the members can be given due accord and respect during the period of debate. The gentleman has the floor.
Thank you, Mr. Speaker. I rise today because the House of Representatives has a responsibility and a duty to protect the integrity of this institution. And what we learned from the documents released by Jeffrey Epstein's estate is nothing short of alarming. Those documents show that Delegate Stacey Plaskett, a sitting member of Congress, coordinated her questioning during an official oversight hearing with a man who is a convicted sex offender, a man whose crimes against minors shocked this entire nation. Let me be clear, this was just not casual contact. There were deliberate communications, and they shaped her official line of questioning in a congressional hearing. The American people expect honesty. The American people expect integrity and judgment from their elected officials. They expect members of Congress to conduct themselves with one word: decency, not to seek advice from a predator who exploited minor children. This resolution does not accuse. It acknowledges what is documented. It censures Delegate Plaskett for her conduct, removes her from the Intelligence Committee, where her judgment is paramount, and directs a full investigation into the extent of her relationship with Mr. Epstein. Some will try to spin this as politics, but protecting the honor of this body is not partisan. It's not Democrat. It's not Republican. Standing against a convicted predator's influence in our proceedings is not partisan. It's basic decency. We cannot pretend this didn't happen. The American people deserve better. Speaker, I reserve.
The gentleman reserves. The gentleman from Maryland is recognized.
Thank you kindly, Mr. Speaker. I yield myself such time as I may consume.
The gentleman is recognized.
And I rise in opposition to this resolution. We're here today on the floor to support the complete disclosure of information related to Jeffrey Epstein and his billion-dollar international child sex trafficking ring. And our side of the aisle, at least, supports the release of information relating to anybody who had anything to do with it, whether they're a Republican, a Democrat, an independent, or what have you, period. We insist on complete, full disclosure. This resolution has nothing to do with that. This seems to me to be one more pathetic effort to distract and divert attention from the fact that the president's name appeared more than 1,000 times already in the small fraction of material released on Epstein, and from the failure of the majority to move to disclose this information. And it is this bipartisan group that we've had behind the discharge resolution, which has insisted on bringing this to the fore, and we've got nothing but obstruction, opposition, resistance, evasion, distraction, and diversion from the other side. And now we get one more resolution like this. The resolution actually proposes a disciplinary censure against Representative Stacey Plaskett, but amazingly alleges no misconduct. It does not allege the violation of the Constitution. It does not allege the violation of a federal law or a state law or local law. It does not even allege a violation of the ethics rules of the House of Representatives, and yet they want to censure her and throw her off of her committee. This, a distinguished former federal prosecutor, diligent public servant, representative of the people of the Virgin Islands. Now, criminal justice has two parts to it. One is insisting upon legal accountability for people who do wrong. The other part of it is due process, which may be the two most beautiful words in the English language, certainly the two most beautiful words in the Constitution of the United States. It's due process that protects all of our freedoms and our rights against the arbitrary power of government and the will just to punish somebody without any process at all. But that's exactly what's going on here. Think about it. Ghislaine Maxwell had due process. She had a right to counsel. She had a right to hearing. She had a right to hear the evidence against her. She had a right to put on her case. She had a right to cross-examine. She had a right to a neutral, impartial tribunal. She had a right to unanimous verdict of a jury. And all of that she had, and she was found guilty. And that's why she was sentenced to jail for 20 years, even though Donald Trump has transferred her from a real prison to a prison camp where she's gotten very special pampered treatment, like she's in a Trump hotel. She gets room service to her cell. She gets gym privileges other inmates don't get. She gets to use the warden as a go-between with people outside of the institution and so on. But in any event, she had due process. Donald Trump had due process. He was convicted on 34 felonies, but he had the right to counsel. He had the presumption of innocence. He had a unanimous jury trial. They had a right to cross-examine everybody, put their own witnesses on. Now, they want to take a former United States prosecutor, the representative of the people of the Virgin Islands, and without even going to the ethics committee, much less a court, they want to arraign her on some charges based on a newspaper article that she did something lawful. However ill-advised it may have been, she took a phone call from one of her constituents. Now, I don't think it is the position of the very distinguished gentleman that if we find Jeffrey Epstein on the phone with Donald Trump, he should be impeached for it, or is that his position? Is his position that any time Jeffrey Epstein got somebody on the phone, and he got a lot of people on the phone, that person is suddenly guilty? That sounds like guilt by association. That sounds like collective guilt. Our minority whip introduced a perfectly reasonable amendment to say, let's refer this to an ethics committee. Let's have a real hearing. They didn't want to have a real hearing. They want to rush to judgment. Why? So there can be some headline that will please Donald Trump tomorrow instead of a unanimous statement, or forgive me, I think the distinguished gentleman from Louisiana may have dissented, but an otherwise unanimous verdict of the House of Representatives that the American people want all the files open. We've had enough of the cover-up. We want all of the truth. We want the survivors and the victims to have the possibility of accountability. Well, they want to give them another headline, which is that they've arraigned a Democratic member for taking a phone call from her constituent, Jeffrey Epstein, in the middle of a hearing. And of course, I don't think there's any rule here against taking phone calls in a hearing. Now, if you want to actually give her the chance to explain what happened, then we would take it to the ethics committee. I still don't see what the charge is. Where is the ethical transgression? Where is the legal transgression? Are you saying anybody on your side of the aisle who had a phone call with Jeffrey Epstein should be censured? Be careful your answer there, because there's a lot more that's about to come out, right? So you should think about what is the principle behind this rush to judgment. I want to close just with this thought, because I know there were a lot of people in the chamber who were here when this happened, and a lot who weren't. There was a move to expel George Santos, who was a Republican member of the House from New York. And it was the same kind of rush to judgment, absolute political frenzy. And I looked at it for about 60 seconds. And, I was a professor of constitutional law, so call me a legal nerd. But I said, wait, this guy's not been convicted of anything. Well, he's a Republican. Yeah, I know he's a Republican. He was not convicted in criminal court. To my knowledge, he had not been arraigned yet or convicted of anything in the ethics disciplinary process. They just said, well, there's bad press. We want to get rid of him. Beware of what you wish for. Is that the rule that you want here in the House of Representatives? That you can just draw up a member of Congress in 24 hours or 48 hours because there's a bad newspaper article without asking any questions, without giving that person any due process at all? Is that what it's come to at this point? I mean, all we're asking for in the Epstein files is release the materials so we can check it out. They want to go ahead and censure and remove from a committee a distinguished member of the House of Representatives with no due process at all. I reject this. I hope the whole body will reject this, just like I voted and spoke against removing George Santos, a Republican on the other side of the aisle, because he had gotten no due process. I hope all of our colleagues will reject this absurd rush to judgment and attempt to change the subject here. I reserve the balance of my time.
The gentleman reserves. The gentleman from South Carolina is recognized.
Mr. Speaker, before I yield time to my good friend Louisiana, Representative Raskin, I will be careful in my remarks. You need to be careful with your facts. You have an 11-year veteran of this body who should know better. You have an 11-year member of this body who took money. It wasn't a newspaper article. It was a fact. She took money from Jeffrey Epstein. It's ironic that you're taken up by defending Ms. Plaskett, which is going to the Ethics Committee, but she's lost her willingness or lost her ability to serve because she got irrational judgment by taking money from a convicted pedophile of young children. And it's unfathomable that you're taking the position that you are. These are facts. You mentioned Ghislaine Maxwell. She's not a sitting member of Congress. She, as a sitting member of Congress, she has relinquished any sense of duty to serve on these committees. With that, I want to yield as much time as needed for my good friend Louisiana, Mr. Clay Higgins.
And the chair would remind all members to please avoid engaging in personalities to direct all comments through the chair. The gentleman from Louisiana is recognized.
I thank my colleague, Mr. Norman from South Carolina, and I thank my colleague, Mr. Raskin, for the salient points that he has brought to this debate. I also defended George Santos on this floor and opposed the means by which he was expelled. I think it was beyond the pale, and this is a responsibility that we bear in this body, is to determine the means by which our colleagues shall be reprimanded or disciplined. And the Constitution is clear on this. My friend Mr. Raskin knows full well that this body controls the means by which and the rules by which the members of Congress shall be disciplined. So we've had variances of opinions regarding, the exact disciplinary actions that should be embraced or rejected, member by member. But let me say that in this case, Ms. Plaskett's receiving text messages, this was so alarming to me. When I saw this and read it, I didn't believe it. I say to my friend, I thought perhaps it was media from a satirical site. It couldn't possibly be true, because we all know that a text message, a text exchange is rather intimate in the realm of communications. And to pierce into an actual congressional hearing for a member of Congress to receive and respond to a text message during a hearing, that is quite familiar, is it not? And this was shocking to me, that a member of Congress would be exchanging text messages directly with Jeffrey Epstein in 2019, at which time he was being prosecuted federally by the first Trump administration. He had received some nature of a sweetheart deal back in 2007 and avoided federal prosecution by pleading no contest to some level of state prosecution, where he was sentenced, Mr. Speaker, to 13 months. My understanding, he did 11 months, and at the easiest time that could be done. He walked every day during the day on a work release program. So that sweetheart deal, let me say, should be looked at. And now, to my horror, who has come to light that should be looked at? What was her involvement? Was there some involvement then? She's a good lady from the Virgin Islands. Where did Jeffrey Epstein live? In the Virgin Islands. She was a constituent in 2019. Was she a friend in 2007? During her service to the DOJ, which my friend has brought up, was there any interactions? These are the questions we have. The good lady from the Virgin Islands has crossed the threshold of reasonable suspicion, and therefore she should be investigated. During said investigation by ethics, and I would recommend by DOJ, and I would recommend by oversight and judiciary committees. Meanwhile, she should absolutely be removed from the House Select Committee on Intel. This, Mr. Speaker, is my position. I presented without note for the betterment of the debate of this body, and I yield my time back to the gentleman from South Carolina.
I reserve.
From South Carolina, the gentleman from South Carolina reserves. The gentleman from Maryland is recognized.
Thank you, Mr. Speaker. It's always a pleasure to hear my friend from Louisiana. Both of the Republican speakers have said this demands an ethics investigation. I think Mr. Higgins just said it should be investigated by oversight and by judiciary, as well as by ethics, as well as by others. This resolution censures her and punishes her before there's been 1 day of investigation. There's been no investigation at all. That was the whole burden of the minority whip's amendment. It was to say, let's have an investigation, refer it to the Ethics Committee. That's why the distinguished gentleman from Louisiana and I both voted against, and we got a majority to vote against censuring or expelling even George Santos without any ruling by our ethics disciplinary body. Isn't that putting the cart before the horse? I don't get it. I wish one of you could explain that to us, why we should censure her before there's been 1 day of actual investigation. If being on the phone with one of our constituents, even an evil, sinister force like Jeffrey Epstein, and of course, he has said that he considered Donald Trump the most evil person he ever met. He said, without a redeeming bone in his body. So I agree, people can say different things, but Jeffrey Epstein, to me, disgraced himself. But in any event, people want to know, well, what were the contents of that conversation? Why was Ms. Plaskett doing that? I'm sure she's got a good explanation. We're talking about a distinguished lawyer and federal prosecutor who was in the middle of a hearing, which is something that members do all the time, is to talk to people in hearings about different things. But let me ask, if it's now the standard that just to be on a phone call with somebody establishes guilt by association, what about all the members of this body or of the U.S. Senate who were on the phone with January 6th insurrectionists and President Trump and his associates who were trying to block the certification of the election as people were chanting, "Hang Mike Pence"? A lot of phone calls, a lot of traffic going on. In fact, that's why our Republican colleagues dealt themselves $1 million cash.
Legal residents and immigrants who pose no threat to public safety. The Trump administration justifies this campaign.
Had been subpoenaed lawfully by a grand jury. They were treated like every other American citizen because their names came up as potentially being involved in that conspiracy to somehow shut down proceedings in the House and the Senate. Now, are we saying just because they were on a phone call, they're guilty of something, we should strip them of their committee assignments? We should censure them? Have we gotten to that point? I mean, come on. This is the House of Representatives of the United States of America. Let's stick by the Constitution. Let's stick by due process. Let's go through the rules. I yield 5 minutes to my distinguished colleague from Connecticut, Representative Himes.
The gentleman from Connecticut is recognized.
Thank you, Mr. Speaker, and I thank the gentleman from Maryland. I'm not going to speak today about Jeffrey Epstein or January 6th. I'm going to confine my remarks to two things that I know about. And I'm going to take a deep breath right now Because to stand here and to have to listen to the gentleman from Louisiana in the guise of just asking questions besmirch one of the finest members I have had the honor of serving with, I would think would offend the sensibility of anybody in this chamber. But I'm going to limit my remarks to two things I know very well. Number one, the House Permanent Select Committee on Intelligence and what we need to do to preserve that very special environment. And number two, the character of Delegate Stacey Plaskett. On HPSCI, I've served for 10 years. And with Chairman Turner and now with Chairman Crawford, we have fought for that decade to keep the Select Committee on Intelligence immunized from the sewage that flows through this chamber, the partisan attacks, the hideousness. And by and large, we've been pretty successful, with one exception, when that committee got involved in the political investigation around Ukraine in the first Trump administration. Every single day, the leaders of that committee work hard, establish friendships, and do the work we need to do to make sure that the toxicity and the sewage that we're hearing right now don't impinge the critical work of making sure that our intelligence communities are keeping Americans safe and not violating civil liberties and not doing things inconsistent with the desires and character of the American people. This effort, put forward by a bunch of people who haven't served on that committee and who have no idea the comity and the grace with which that committee serves, you, sirs, will hurt this committee badly. And I expect every Republican on the Intelligence Committee, and I'll say it again, I expect every Republican on the Intelligence Committee who know Ms. Plaskett and who know the committee to vote no on the idea that without evidence and without due process, Ms. Plaskett should be removed from that very special committee. This resolution would strike a devastating blow to HPSCI's ability to work effectively by removing a member in good standing based on a newspaper article about texts. No due process, no evidence, nothing offered other than a newspaper article which has moved the gentleman from South Carolina, a member who is consistently engaged in a bipartisan and productive way with the committee's work, to make some unrelated political statement will do profound damage to this essential committee. Now let me just talk for a moment about Ms. Plaskett. I've served in this institution for 17 years, longer, I think, than most people in this chamber. And I have not had the honor of serving with somebody with the integrity and the commitment and the hard-working bona fides as Ms. Plaskett. We can argue about the wisdom or the judgment associated with those texts. I'm told that apparently Mr. Epstein was a constituent. But on any one of us, our worst day, our biggest misjudgment is not to be judged without any due process, especially in the context of this superb member, this critical member of the Intelligence Committee. The result of this resolution, if it were to pass, will be to undo the efforts of the Republican Speaker and the Republican Chairman of the Intelligence Committee, Mr. Crawford, to restore the committee to what it was intended to be. And while the bill for that decision won't come due immediately, it will come due over time in the form of a less accountable.
People off the streets, while they're dropping off their kids at school or heading to work, or simply looking Hispanic, good enough to be arrested and deported. Don't take my word for it. Listen to what U.S. District Court Judge Jeffrey Cummings said. In a lawsuit challenging warrantless immigration arrest in Illinois, Judge Cummings read from a summary he and his law clerks compiled of more than 150 pending immigration cases in which arrestees were challenged their deportation. The judge said the circumstances of the arrest show that Operation Midway Blitz is not targeting hardened criminals, not targeting the worst of the worst. In that case, the Trump administration provided a list of more than 600 individuals detained during Midway Blitz. By their own data, just 16 of the 1,600 detainees have any criminal history that poses a high risk to public safety. Do you know what percentage that is, Mr. President? Less than 3%. Terrorists, rapists, murderers, criminally insane. Less than 3% have any criminal background. All of this confirms what I've been saying for months. What is happening in Chicago with Midway Blitz is a political theater to spread fear, not reduce crime. Oh, they struck fear in the hearts of the kids at this daycare center. They may never forget what they saw that day when the agents came in their camouflage and their mask and whisked this poor woman out to deport her, and started off by sending her to Indiana and then releasing her. It made no sense whatsoever. This is political theater at its worst. Chicago deserves better. America deserves better. Reports indicate Border Patrol Chief Greg Bovino is leaving the city of Chicago. Let me tell you, he couldn't leave too soon for my conclusion. However, we expect immigration raids to continue in the city. And Mr. Bovino has already taken his administration's brutal tactics that they've been practicing in Chicago to Charlotte, North Carolina. In just one weekend, DHS agents raided a church and arrested at least one U.S. citizen simply because he looked Hispanic. In Mr. Bovino's own words, and I quote, "It wouldn't surprise me to see us in a city near you." So I asked my colleagues, especially my Republican friends, who value liberty and freedom as much as I do, what is stopping this government from deploying tear gas in your home city? What is stopping them from pointing guns at your constituents? What is arresting your fellow neighbors without cause mean to you in the future? It's a legitimate question. Don't look the other way out of personal or political loyalty to this president. Look straight in the eyes of the people you represent and tell them you stand for the Constitution and the well-worn history of this country where we have tried to push back when tyrants emerge. It's on all of us to call out these abuses of powers and this trampling of civil liberties. How can we say to Miss Diana, we're sorry? We can say it by ending Midway Blitz as fast as possible and by reassuring the families there that we want to have a safe nation, but not at the expense of our basic liberties. I yield the floor.